My name's Paul Ship. I'm with Kansas Legal Services, and that's the little logo on the screen there, the little green one. Kansas Legal Services is a statewide law firm, and we are a nonprofit, and we partner with the Atchison Area United Way. And what we do is we provide legal services at no cost to individuals who cannot otherwise afford an attorney. And I was approached by the director of the United Way to maybe help out with some issues in the community and maybe do some education about landlord-tenant issues. And I've done landlord-tenant issues across the state. And in the past, I've done a series of presentations, and oftentimes people want landlord-tenant education to be like 1 hour and you can know all your rights. And that's really not a possibility. It's not possible to learn everything there's to learn about landlord-tenant issues in one session. And so when I was approached, I suggested that I maybe give one presentation on one topic and make it very narrow so that it's easy to digest. And if this is nice and people like that, then I will come back and do another topic. And we can go from start to finish. And so, again, the purpose of this program and the purpose of what we're doing here is to provide some education about one topic. And so, and with that, the topic today that we're going to talk about is, before we even get started, is landlord-tenant issues. And there's this problem I often see with landlords and tenants that I don't like. Tenants are often in the position where they're trying to say that they're the victim and that the landlord is an evil human being and they're abused. The reality is there are bad tenants and there are bad landlords. And the purpose of this sort of presentation and discussion is to educate tenants and landlords, more or less, on the best way to communicate and have everyone know what their rights are. And I'm not really interested in propagating, maybe that's a big word, or putting forward, and I'm not interested in making tenants out to be victims of evil landlords, and that's just the way it is. Most of the time, landlord and tenant issues start at the very beginning, and people make mistakes from the outset. And so this presentation is going to discuss the topic of delivery of the rental unit, and when the tenant moves in and why that is important, and because that's where the problems actually start. And so we're going to talk about the duties and obligations of the tenant and the duties and obligations of the landlord. And with that, you need to understand that in Kansas, your rental with your landlord is governed by two things. The first one is the Residential Landlord and Tenant Act, and that is the law, and the statute numbers are on that slide. And then the other thing that your landlord and tenant agreement is governed by is your rental agreement. And so your rental agreement is an integral part of what it is that you're going to be dealing with when you start this relationship between the tenant and the landlord, because maybe the landlord's not your boyfriend or your girlfriend, but there is a relationship going on there. And so when you move in, the first thing that you're going to do under the law, and there's a statute for it, and if you want, after this presentation or at some point, these slides will be made public, and you can click on the links. And so if you go to this slide, you can click on the statute number there, and you can see that that's what the law says. The punchline is, under the law, there's an assumption that the landlord and the tenant within 5 days of moving in are going to do something called an inventory of the premises. I'm going to put a plug in for forms that I have developed and that are still being developed. And there'll be a link for those as well. And I have a suggested rental property inventory that you can do. Most landlords already have one. You're not required to use the one that I prepared, but if your landlord does not have one, then you need to get one. And so when you do the inventory of the premises, that's when you are going to walk around your apartment and you're going to look at all the problems. There's 60 nail holes in this wall, or the toilet leaks, or there's a stain on the carpet. whatever the issues are, and you're going to write down each and every one of them. I remember when I first went to college and had to do an inventory of my dormitory, and I remember how tedious that was. And everyone always said that if you didn't do it, then when you move out of the dorm, you're going to get charged. Well, the same is true with a landlord-tenant relationship. A lot of tenants fail to do the inventory, and they get lazy and they don't do it. Or landlords just say, don't worry about it. Well, you should be worried about it. And the reason why you should be worried about it is because one day you're going to move out of this place. And if there is no inventory, the landlord's not going to be able to say that you damaged it, because the landlord's not going to have is not necessarily going to have an inventory of the way it was when you moved in. It has nothing to compare it to when you move out. If you fail to do it, then you might be leaving stuff on the table and end up getting yourself charged for things that you shouldn't when you move out of the rental property. And I have another presentation I give on moving out and security deposits and all that, but we're not talking about that today. Today we're talking about what are you supposed to do and what are your obligations. And so when you go through that rental property, there's a cartoon that I have, and I don't know if you can see that clearly or not, but the punchline here is you get all the information you can, and you'll worry about whether you're going to need that information later. Hopefully when you move out at the end of the rental agreement, you're not going to need any of it, and you're going to have a great landlord who understands and does not charge you for things like normal wear and tear. In the process of going through wrong with the rental unit, like leaky roofs or busted toilets, or there's something significantly wrong with the rental unit, and you're having buyer's remorse, and you're thinking to yourself, I should have never moved in here in the first place, then you need to do that. And I've just got a couple slides here that show the types of things that you're going to write down, and you're going to be really tedious when you do that. And so what happens when you've moved into the rental unit, or you're halfway moved into the rental unit, and you have buyer's remorse, and you're like, this place really, can I say the word sucks? This place really sucks, and I don't want to live here anymore. Or maybe I'm going to go ahead and stay here. I think my mic turned off. No, it's back on. Okay. It hit the floor. I apologize. And you decide that you don't want to live there anymore, and you're thinking to yourself that this is really a bad deal. And so when you're thinking about that, you need to understand what the responsibilities are for yourself and your landlord, and you need to understand what the landlord's responsibilities are. And so at the time of move-in, the landlord has to deliver the rental unit in accordance with the law and the rental agreement. And so if you remember at the beginning of this topic, I said that the relationship between you and your landlord is going to be governed by those two things, the rental agreement and the law. And the law says that the landlord has an obligation to deliver the rental unit according to the rental agreement and the law. And the law is KSA 582553. And the rental agreement, sometimes rental agreements are oral, sometimes rental agreements are in writing. Most of the time they're going to be in writing, but not always. And so if your landlord has agreed to do some things, like sometimes I get clients calling, they're like, the landlord told me that I was going to have a washer and dryer in this unit. I moved in and there isn't one there. Well, if the landlord did not provide that, then he's giving you a door to say that I don't want to move in here because you did not deliver what you promised. Maybe the landlord says, we'll replace the carpet before you move in, but you get there, but it's still the same crappy carpet that you had, when they showed it to you, and the landlord has not replaced that carpet or the sink, or sometimes there's defective toilets or whatever there is going on in there. And so if the landlord made those agreements, then the landlord needs to live up to them. Under the law, the landlord is required to comply with the local building and housing codes that materially affect health and safety. And the landlord must exercise reasonable care in the maintenance of the common areas. Atchison does have some housing codes. They're not quite as exhaustive as they are in other communities, which is a little bit frustrating. But if you want to know what the housing codes are for Atchison, there's a spot on the website for the city that can direct you to that, and then the slide, and later you can click that and you can read that for yourself. Most municipalities, and maybe Atchison will change its mind in the future, but at this time it has not. But other municipalities and jurisdictions will adopt things called the International Property Maintenance Code, or the International Property Electrical Code, or whatever. And the municipalities and areas of the state that adopt those sorts of things, they tend to have a little bit better housing situations because it gives a little bit more teeth to the building codes inspector for wherever it is that you live. But the local building codes inspector is going to be pretty much stuck with these. And I'm not going to go through the gory details of the housing codes for the city of Atchison. The big point here is when you move into your rental property, the landlord has an obligation, has a responsibility to make sure that the rental property is in compliance with those local building codes, period. The landlord also has an obligation to make sure that the facility or the rental unit complies with KSA 582553. And in that, the electrical, plumbing, sanitary, heating, ventilating, air conditioning appliances, all of those things that are provided, they're supposed to be in good working order. And if they're not in good working order, then the landlord is in violation of the Kansas Residential Landlord and Tenant Act. The landlord is supposed to provide and maintain on the grounds for the common use by the tenants appropriate receptacles for removal of garbage, rubbish, and any other waste. And I often see this in like trailer park situations, and that's another deal. But your landlord needs to provide you with the facilities to get rid of your garbage. The landlord's also supposed to supply running water and reasonable amounts of hot water at all times and reasonable heat. Most municipalities have additional regulations on that with specific temperatures and specific times of the year. But the Kansas Residential Landlord and Tenant Act does require the landlord to at least provide running water and reasonable amounts and hot water. And there are some situations when landlords are pretty deficient in that. And oftentimes when tenants find themselves in that position, they really don't know what to do. And so if you're in a position where you're like, you know what, I got buyer's remorse. Well, the best advice I can give you is get out early and fast and get out of there. And if you want to do that, you need to do it according to the law. And in Kansas, under the law, if the landlord fails to deliver possession of the rental unit to you, you've got to give the landlord at least 5 days written notice that you're terminating your rental agreement and you're getting out. And that, I mean, there's no ifs, ands, or buts about that. If you want to see a form for that, if you click on the links that are here, there's a form for that, and I have one here, and we'll provide those links later. But what you're going to be telling the landlord in this written notice when you're saying I'm terminating this rental agreement is, and then maybe I'll read that, it might be boring, but I'll just read it out loud. But you're going to say something like, pursuant to this law, I am notifying you that you failed to deliver the rental unit in accordance with the rental agreement and KSA 582553. And then you're going to provide a descriptive list of the problems, and you're going to write it on the back of the form or on a separate page. And then you tell the landlord when you're going to vacate. And so again, when you start moving in, you got two choices. You can either terminate or stay. And if you're going to terminate, you need to give the landlord that 5 day written notice. And I know that this doesn't show up very well here, but there's a cute little penguin, and it usually runs off the screen, but you can't see that on the thing. But you need to give the landlord your 5 day termination, and then you're going to be out of there. That's absolutely required. Your other option, if I'm going to go back to that slide, is this, under the law, we call it demand for performance. You know, like if someone says, I'm going to dance for you, and then they don't, then you can demand that they dance. If your landlord promises you in the rental agreement certain things, and then the landlord does not live up to those things, or the landlord does not deliver the rental unit in accordance with the law, then you can terminate or you can stay. And so if you choose to stay, and unfortunately at legal services, I know the story, you know, the tenant gets all these crazy promises from the landlord that the landlord's going to fix it. And then they move in and the carpet stinks and the sink doesn't work and the bathtub clogs up and it backs up and it's really a ghetto hole, and they just want to leave, but they can't leave because the landlord won't give them their security deposit back and they won't give them their month's rent back, and they call us and they're asking me, what's the magic wand you can wave to make this, you know, all better? And the answer is, I don't have one. You know, you need to give them the 5-day notice and get out. And then the tenant's like, but I don't have any money and I can't get out and I have nowhere to go and it's better to sleep here than on the street. Okay, so what are you supposed to do in that situation? And so if you go back to that law that I was talking about, under subsection B, the law says that you can demand performance. And the law says that rent abates until the landlord delivers the rental unit in accordance with the law. Okay, and then you can demand performance. And the way that you demand performance is you need to complain. And you need to provide your landlord with a written demand. And this written demand basically says, this place is horrible and it doesn't comply with the rental agreement, it does not comply with the statute, but I'm not going anywhere, I'm going to stay. And I demand that you fix the following things. And then you fill this out and you tell the landlord why you're staying and you demand what needs to be fixed. And so in the process of doing that, inevitably the next month is going to come and you're going to need to pay that rent. And unfortunately, even though KSA 582560 says that rent abates until the rental unit is delivered, unfortunately, even though the statute says that, you're still going to have to pay your rent, because if you don't pay your rent, then the landlord is going to file an eviction against you. Now, you will have a defense in court, which is a whole nother presentation when we talk about evictions and we talk about all the defenses and all the offenses and all the things that you can say. And what I'm going to tell you now is, if you're in that kind of situation, it would be really nice if you gave the landlord a written demand that he fix all the problems, because then you're documenting exactly what's going on, because you're communicating. You're communicating with the landlord. And so when the next month comes and you have to pay that rent and you just got that bad taste in your mouth and you're not happy about paying that rent, you're going to pay that rent under protest. And so what you do is you take the check, you pay the rent in full, and then you pay the rent under protest. And what this particular form says and what this particular document says is, I'm paying the rent on this date and I shouldn't have to, and it's a nice tidy way to complain, and it says all the things that most tenants should say. And then on the back of that form you can write down the details of exactly what it is that you're talking about. And then along with that, as time goes on and when you stay there, you're going to continue to pay that rent under protest. Because, I mean, that's what you're going to do. And if you decide that you're going to leave and you finally get to a point where you're actually going to move out, then I will suggest that you serve the landlord with your 5-day notice that you're moving out because the rental was never delivered in accordance with the law. And so I've yet to have a tenant actually follow this process, but that's why I've been educating people about it. Most of the time, if you move into a crappy situation with a crappy landlord, if you tell the landlord up front, this place really sucks, and you threaten the landlord to leave and you do it in writing and you give them stuff like this, most landlords are either going to fix it or let you get out of the rental agreement. Although I do know there are way too many people that get caught up in the process and they're just kind of stuck. And so with that, inevitably what I always deal with in landlord-tenant cases when this kind of bad situation occurs is codes enforcement gets involved. There are some municipalities in Kansas, and I'm not going to name them specifically, but I know where they are. They have like rental inspection programs, and if you want the codes inspector to go inspect your rental unit before you sign the rental agreement or before you actually move in, you can call them in advance and And you can look it up. They even have online, you can look up prior tenant complaints about the rental unit. I don't think Atchison has anything like that. And maybe that's something that they could look into in the future. But all too often when tenants get codes involved, unfortunately, they seem to get codes involved at the eviction stage, when the reality is they should have gotten codes involved at the very beginning of the case. The 5 days that you have at the time that you move in to do the inventory of the premises, if you've got some serious concerns about your health and safety and living there, give codes a call. Now, I certainly hope that the codes office in Atchison doesn't hate me for saying this because they might get an increase in their calls. But the reality is the codes guy is not, or whoever's there, it could be a guy or girl at times. I know that there's some lady codes inspectors in different municipalities as well. But the codes inspector is not on the landlord side, is not on the tenant side. The purpose of codes enforcement is to enforce city code. And their job is to protect the safety and welfare of the people who live in the community. And the only thing they are supposed to do is come in and inspect the rental unit and see if there are any violations with the current codes. And if there are violations with the current codes, then they're going to send the landlord a notice. Most municipalities will also send the person who resides in the rental unit a copy of the notice. And then the landlord's given an ultimatum to fix it within so many days, and then there could be fines and fees and other stuff like that. And some places have codes that are more stringent than others, and some places have more regulations that are more stringent than others. But the landlord is, the codes inspector, again, is a neutral person who is just there to enforce the city codes. Now, from a litigation standpoint, and as a lawyer, have I ever had a codes inspector testify in court? Yes, many times. And the codes inspectors in the places I practice, they all know who I am. And they hate it when they have to come to court and testify. But it does happen. But again, it doesn't have to be that way if you get this process started. If you get this process started on the very front end, and you do not enter into rental agreements and live in units that are just crap in the first place. And so that's why it's important for you to do that inventory, the inventory of the premises. Now, if you do move in and you see minor problems and minor issues, there's another presentation I give about a maintenance request where you notify the landlord. And I'm going to go back to this slide here. Okay. If you start your relationship with your landlord on the right foot at the very, very beginning, then the communication is going to flow between the two of you, okay? And the landlord and the tenant are going to work and cooperate together instead of be at each other's throats. Because good landlords, and there are bad landlords and there are bad tenants, but good landlords want to know that things are wrong with the rental unit. They don't want a sink that leaks to rot the bottom out of the floor under the sink, and they don't want a toilet that doesn't have a good seal to leak, and they don't want a shower that has a crack in it where the water is seeping into the wall, because that's going to grow mold and everything else. And if you give your landlord notice of that issue, then the landlord will have an opportunity to fix it. But again, on the front end of this, because we are talking about what happens in situations when tenants get in these bad situations where they absolutely hate what's going on, you need to go back to, are you going to stay or are you going to go? Should I stay or should I go? And you're going to terminate your rental agreement and get out, or you're going to make written demand for performance, and then you're going to stay and you're going to pay your rent under protest every freaking month, for the whole time that you're there until you get in a position where you can move out. And then if at any time you need to call codes enforcement, don't wait forever. And then communication, of course, is the key. And I know that this particular discussion and presentation always brings up lots of sometimes bad feelings, and people have questions, and sometimes they have questions that might be off topic. And like I said, at the very beginning of this discussion, I'm very willing to come in and talk about other topics and other issues if people want me to do that. Usually the one that I discuss after this would be the document called the maintenance request, and why it's really important for the landlord and the tenant to communicate and to have a good communication between the two of them, so that they're not propagating this I'm a victim and the landlord's an evil person. So with that, I guess I'm at the end, and then I can take questions if need be.
Question: if somebody were to fill out the 5-day form, aside from giving that to the landlord, is there someplace else they need to file that?
No, because you're in this so the question was, if you fill out a 5-day notice and you're getting out of there, do you file it somewhere else? And the answer is no. What you need to do in a situation like this is the most important thing again is that you have your property inventory and condition well documented. We all got these things called cell phones nowadays, right? Take your pictures, document. Have people see it. Have people witness what it is that you're talking about. And keep good copies and be able to reproduce that stuff easily in the future. And when you give the landlord your 5-day notice, it should be well documented, and you should keep a copy for yourself. And so what's going to happen in the future, because there's a risk involved here, because if you're like, hey landlord, this place really sucks, I'm getting out of here, here's my 5-day notice, and here's the inventory, and these are all the things that are wrong with the place, and you get out of there, the landlord could sue you in the future. I mean, that's an option. But if you've got really good documentations and you feel really good about what you're doing, then you should be A-okay. But at the end of the day, a judge in a district court is going to hear your argument that it was crap and you had a good reason to leave, and the landlord's going to make his argument that it wasn't crap and it wasn't as bad as you said it was. And so that's the risk that you take. So no, you don't file it with someone else, but you do keep copies and you keep your documentation, because in the event you are sued for the next month's rent, because the landlord says you can't get out of the rental agreement like that, you can. But at the end of the day, a judge in the future will decide. So I hope that answered the question.
Would you like to tell them that, yes, these forms will be available online?
Yep,
sometime tomorrow.
Yeah, the forms are available online, and in all honesty, I started creating these a few years ago. There's an organization out to speak called HCCI, which is Housing Credit Counseling, and I took a lot of issue with some of their forms, and I did not think they were very user-friendly, and I thought that maybe at Legal Services we could do a little bit better job on educating people, and so that's what I'm trying to do here. And so there's a list of forms, and you might look through this list of forms online and you'll see where some of them say coming, in the future, like it's in the works. And so, and if you have a suggestion for a form and you're like, I want to be able to tell my landlord a certain thing a certain way and I don't know how, then shoot me an email and tell me, and then we'll put it on the to-do list.
Any other questions you think might need to be answered? We don't have any other questions, so.
Good.
Do you want to wrap things up?
Yeah, I don't have anything else to add, but if I'm invited back and you want me to do this again, I'd be glad to. I would just do a different topic and we would just move through, and what I have told there's renters' rights groups across the state, and what I tell them when I present to the different groups is, if you have a suggestion for a topic, tell me, and then we'll discuss it.
We have one other question that just came in. She's saying
the 1430-day notice.
Right. The 1430-day notice, that's a whole hour discussion. And so that's a whole nother deal. Right. And if I were just to explain that in like a minute and a half or less, the 1430-day notice is a situation when you've moved into the rental unit. The assumption is everything was pretty good, but you stayed there for a little while, but something broke or something's bad, and the landlord won't fix it. And so, and if the landlord won't fix it, then you have a right under the law to say to the landlord, I'm terminating my rental agreement, but you have to follow a specific procedure. And a 1430-day notice is not a maintenance request. And so typically the next thing I talk about is the maintenance request and the importance of communication between the landlord and the tenant. But if you want a 1430-day notice, the forms link that is provided in the future There will be a 14 30-day notice in there, and then there's a description of how to use it, and that could be another 30-minute discussion in the future from start. Like that would be one discussion all by itself.
All right, well, if you've covered everything for this evening,
I've covered it.
okay,
All right.
just say goodbye.
Goodbye.